One of our top stories, today's judgment day for former Social Development Minister Bathabile Dlamini. She's back in the Johannesburg Magistrate's Court where she's facing perjury charges. Dlamini allegedly lied under oath during an inquiry which dealt with the social grants crisis. Executive Director of the Helen Suzman Foundation, Nicole Fritz, joins me now just to tell me what she's been thinking. We've been listening to the Magistrate, Betty Khumalo, hand down judgment. How do you think it's going so far, if you have also been listening?
I haven't had an opportunity to listen. I understand that there is a break in the proceedings at the moment. I think it's important, though, to underline that this is an incredibly important moment in sort of holding public officials responsible. The public will know that these perjury charges, in fact, stem from the social grants crisis, the long-running social grants crisis, which you have already referred to, and it really goes to the minister's responsibility for that crisis, and what she told the Constitutional Court, the highest court in the land. A special Section 38 inquiry was established in order to determine her responsibility, and on the basis of that Section 38 inquiry, the Constitutional Court found that she should be ordered to pay costs in her personal capacity, but that they also then ordered that the National Prosecuting Authority consider instituting charges of perjury in respect of former Minister Bathabile Dlamini. And this case and this judgment today stems from that set of events.
And, besides the importance of it, in terms of making sure that there's accountability by ministers who, for instance, are found guilty of doing something wrong or of, overseeing a project that basically had detrimental effects on the poor. I think that's what, a lot of people have been saying is important. What would you think, what would normally be, the punishment for being found guilty of perjury?
Well, perjury is a crime which, if found guilty, one would generally be then sanctioned with a non-custodial sentence. So one would be looking at paying a monetary fine. But I think the wider context here is that a finding, a conviction on a charge of perjury would underline that we had a former minister who held one of the most important offices in our country, given the fact that a third of South Africans are recipients of social grants, that her actions actually led to a situation where there was the potential for those social grants to actually be stopped. The payment thereof was in effect endangered by her actions. And so, it is important to understand that perjury is essentially a ruling which says the person convicted has lied to a court. But in this context, it is a minister who has deliberately sought to mislead the highest court, the Constitutional Court, as to her accountability, as to her responsibility in respect of a crisis that potentially, were it not for the Constitutional Court's interventions, would have seen a third of the country whose livelihoods essentially are guaranteed or based on the payment of the social grants, of that social grants, those social grants being imperiled, not being paid, and leaving, as I said, many millions in South Africa even more destitute than they currently are. And I think it is that context which really, I think, puts into perspective how egregious the responsibility is.
And going back to it, this was all because of what it seemed to be greed and power struggles. But also looking at the fact that she had actually applied to the court. Of course, they dismissed her application to have the charges against her dropped, saying that the state doesn't have much evidence because it only brought a certain number of witnesses and didn't have key witnesses to come forward during this particular trial, talking about some affidavits that were written during the time that the case was still in the Constitutional Court. What did you make of the fact that her defense team is saying the state doesn't have enough evidence and that these charges should have been dropped?
Well, obviously that application for a discharge was not adhered to by the court. We're now waiting for determination of the verdict in respect of the trial. I can't preempt or speculate as to what that verdict will be, but I think one also has to recognise that the recommendation of these charges came from a Section 38 inquiry that had been established by the Constitutional Court, and the Constitutional Court endorsed that recommendation. It made that ruling as that recommendation as part of its ruling. It required that Section 38 inquiry and its outcomes be referred to the National Prosecuting Authority so that it consider instituting charges for perjury against former Minister Bathabile Dlamini. So it is not as if that initiation, that recommendation, is based on any flimsy case. As I said, it has the endorsement of the highest court in this country.
Exactly. Well, thank you very much. We've unfortunately run out of time, and I was hoping to speak to the Helen Suzman Foundation because you've been there from the beginning of this case as soon as the judgment is made. But that was Nicole Fritz from the Helen Suzman Foundation. I'll be back with more news for you at the top of 12 o'clock.